Nebraska Appleseed is a nonprofit, nonpartisan public interest law project. We are a statewide organization. Our offices are based in Lincoln. And we like to say that we use all the tools in the public interest toolkit. So you can see there that we do litigation, impact litigation. It's listed first, but we do it as a last resort. After other efforts have failed, we do a lot of public policy and advocacy work, community education and outreach to address four primary issues or four primary constituent groups: low-income families, immigrants, children in the foster care system, and access to health care. And I'm the director of our child welfare program, and that again is focused on systemic issues within the child welfare system in Nebraska. And so a few of the issues that we're working on right now are monitoring the child welfare reform, gaps in the system for children's behavioral health services, and that's where some of our reasonable efforts work sort of fits in. And then we have historically done a lot of work looking at cultural issues in the child welfare system, so sort of crossover issues between cases involving immigrant children in the child welfare system and also ICWA issues. And then we also have what we call the Foster Care Reform Legal Resource Center, which is an effort to work with frontline attorneys, either guardians ad litems or attorneys representing foster and biological parents, and to provide them with resources to try to address systemic issues in their individual cases. And so one of the primary ways we do that is through a listserv. And if you're a GAL or a parent's attorney and aren't already on that, please let me know and we'll get you signed up. And then we have a staff of 13 lawyers, social workers, community organizers, and there are 16 Appleseed centers across the country. Just a little bit about us. Just an overview of the presentation today. I'm going to give a little bit of background on federal and state statutes on reasonable efforts, and then go through some best practices in reasonable efforts before talking about some strategies that can be used to try to enforce reasonable efforts in juvenile court cases. And then I'm going to talk a little bit about ways to address reasonable efforts issues outside of court. Okay, so the reasonable efforts requirement is set forth in Nebraska statute at 43-283-01. And as I hope all of you are aware, there are certain exceptions to reasonable efforts if aggravated circumstances are present for specifically enumerated criminal violations, and also if the parental rights of the parent to a sibling have been terminated. And I just want to pause and mention there's been, I think, a lot of focus on aggravated circumstances, and rightfully so. I think it's important to try to identify cases where we can, expedite permanency if reasonable efforts aren't going to be successful. But sometimes I think we don't realize that we could all, in many of the cases where aggravated circumstances or an exception could be present, you could also just go straight to termination of parental rights in those cases, because a lot of the facts that would support aggravated circumstances or exceptions also have parallel statutory basis for termination. And then reasonable efforts is also referenced in the Family Policy Act in the Nebraska statutes, and then in the termination of parental rights statute, it's subparagraph 6, which states that reasonable efforts to preserve and reunify the family have failed to correct the conditions leading to the adjudication. And then I just wanted to mention that Nebraska appellate case law has been really clear that reasonable efforts does not need to be proven at termination unless that specific subparagraph 6 has been alleged. But then I would also caution that there are some cases, as I read them, where provision of services seems to come in under the best interest prong, and those cases tend to be, it's not reasonable efforts per se, but there's some discussion of services under best interest, particularly when 15 out of 22 is the only basis for termination. And when I cited the R&D case, there's a few other cases that I think tend to go that way. And then reasonable efforts is also addressed in 43-285, which is the court's approval of a case plan. Reasonable efforts is set forth in federal statute in Title 40 of the Social Security Act, and Nebraska statute mirrors federal law. There's also it was actually not that new anymore. There's a new requirement, semi-new requirement for reasonable efforts from the Federal Fostering Connections to Success Act, which was passed into law now almost 2 years ago in October of 2008, and it requires reasonable efforts to place children removed from the home in the same placement unless the state documents that joint placement would be contrary to the safety or well-being of any of the siblings. And then, in addition, when siblings are not jointly placed, the law requires reasonable efforts to provide for frequent visitation or other ongoing interaction between the siblings.
Sir,
Yeah.
is there any case law on that that tells what needs to be documented, whose opinion it is that the children are in danger if they're placed together?
I'm not aware of any case law on that yet. There may be some potentially bubbling up. And I'm also not aware, I think there have been some regulations on fostering connections at the federal level, but I'm not sure whether those address sibling placement. Do you know, Kelly?
I don't think they've decided yet whether that needs to be a court finding or an agency finding. I think they're leaning towards the court finding, but it needs to be final regulations.
Okay. So, yeah, stay tuned. And then in order to receive federal 4E funding, the states must have an approved plan which sets out the reasonable efforts requirement. And so the reasonable efforts requirement at the federal level is essentially achieved through the spending power. And I noted the Souter case. In that case, the United States Supreme Court indicated that there was no private right of action to enforce the reasonable efforts provisions of ACWA, which was the precursor to ASFA. And so what that means essentially is that if there's no right to bring a separate federal action under the federal statute to try to enforce reasonable efforts. I'll talk about some ways that can be done at the state level, but directly under ASFA, or in this case interpreting ACWA, there's no right to bring a separate federal court action to enforce. And what the court said in that case is that the primary enforcement mechanisms at the federal level are the federal reviews, the CFSR, and the removal of federal funding for 4E, which ties in what we'll talk about later in terms of no reasonable efforts findings. The last bullet, if no reasonable efforts finding is made, as I hope you know, and we'll talk about, the state loses the federal match for that case. Okay, and I wanted just to mention the Duane G. case. This is the primary Nebraska case setting forth when reasonable efforts findings should be made. And in this case, the Nebraska Supreme Court indicated that reasonable efforts, if not excused, must be reviewed by the juvenile court at 4 stages in a juvenile case. When removing the child from the home, when the court continues an out-of-home placement pending adjudication, court reviews, and when termination of parental rights is sought under that subparagraph 6 of the termination statute. And in this case, the father appealed a reasonable efforts finding, and the Supreme Court looked at the reasonable efforts statute and the legislative history and found that the reasonable efforts statute doesn't specifically provide for the parent or any other party to bring a separate hearing on the issue of reasonable efforts outside of these 4 stages. And so in the Duane G. case, the father had brought, again, a separate motion. It wasn't within one of these 4 stages, and so the Nebraska Supreme Court affirmed the denial of the reasonable efforts motion. And so what in terms of bringing reasonable efforts motions, which we'll talk about later on in the presentation, my understanding is in a lot of jurisdictions, how this is handled is if a reasonable efforts motion is brought, then oftentimes it will be said or heard within the context of a review hearing. Is that the experience of folks here? Okay. And then I wanted just to mention active efforts. In cases involving Indian children that fall under the Indian Child Welfare Act, the standard is active efforts instead of reasonable efforts. And you can see there on the left is the language of the active efforts, the language of the statute for active efforts. And then on the right-hand side is the Walter W. case, and that's I think one of the primary Nebraska cases addressing what is active efforts in Nebraska. And in that case, the court said that active effort standard requires more than reasonable efforts. It's a higher standard, and that at least some efforts should be culturally relevant. But beyond that, the court said that the active effort standard sets forth vague goals for the court to try to enforce, and it's a case-by-case analysis. And I think the same could be said for the reasonable efforts requirement. Okay, so in terms of what actually is reasonable efforts and what we can do to try to meet it so that we don't face an unreasonable efforts issue, reasonable efforts is required to prevent or eliminate the need for removal, and to make it possible to return a child to the home. And then I wanted just to mention a little bit about what we know about reasonable efforts early on in a case, because I think sometimes it's hard to think about what might constitute reasonable efforts prior to removal, because sometimes it happens so quickly. And there's two cases that I think are helpful in terms of the involvement of the non-custodial parent. The first is the Stephanie H. case. In that case, the children were living with a custodial father by virtue of a divorce decree, and were removed from the father's home because there was a report that the father had sexually abused the children, and the children were placed in foster care. And the mother had visitation with the children about once or twice a month, and petitioned the court for visitation and placement of the children, and that was denied. She intervened and sought placement. That was denied. Then she appealed that order. And on appeal, she alleged that she had been deprived of custody of her children without evidence of her unfitness, and that was a violation of her due process rights. I should mention that prior to her intervening, she had obtained an order in the district court granting her custody. And the Court of Appeals agreed with her and overturned that order. And agreeing that she had been deprived of custody without evidence of her unfitness, and the Court of Appeals held that the placement of a child with one parent as opposed to another in a divorce action does not constitute an adverse finding of unfitness with respect to any other proceeding, in this case a juvenile court proceeding, and that the state has to allege and prove at the detention hearing, in this case, that the non-custodial parent should not have had custody of the child, and that would have been contrary to the welfare of the child. And the Court of Appeals noted that the procedures employed in that case were contrary to the reasonable efforts requirement in the statute. And then there's sort of a related case, Ethan M., where the Court of Appeals held that the placement out of state with a non-custodial parent may hinder reasonable efforts with the custodial parent. In this case, there was a lot going on in this case if you've read it. So I'm just going to mention one sort of key point of it. Ethan was removed from the home because there were other children in the home that had suffered injuries at the hands of their mother. And after the dispositional hearing, the juvenile court approved a change of placement from Ethan from the home of his paternal grandparents to his mother, who was living in California. And the father argued that the juvenile court erred in approving that change of placement. The juvenile court's decision flowed in large part in that case from a determination that reasonable efforts were not required, which the Court of Appeals reversed. And so once the Court of Appeals determined that reasonable efforts were required, this Court of Appeals indicated that this placement change would be contrary to reasonable efforts to reunify Ethan with his father, which was pretty eminent in this case. The Court of Appeals also noted that there was evidence from the divorce case in California that the mother had some significant mental health issues. She had been gone from the home for periods of time, leaving Ethan with the father, and so I think those facts were pretty relevant in that case. So, how do you reconcile these cases? I think primary among the ways to distinguish is that in the second case, there was evidence of unfitness. In the second case, the mother was residing in California. But I think there are important cases in terms of thinking about reasonable efforts early on in the case. It's important to look at non-custodial parents and how they might be able to be involved. And then I wanted to mention the Teresa P. case for the proposition that the juvenile's health and safety are the paramount concern in determining reasonable efforts. In this case, a child was removed from the home, I think a 17-year-old child, after a report that she had received a black eye from her father. And at the detention hearing, the juvenile court, made a reasonable efforts finding based on the safety of the child, and the parents appealed, arguing that there wasn't sufficient evidence to support the reasonable efforts finding. I just want to read this quote. The Court of Appeals upheld reasonable efforts and said, although it may at first blush seem absurd to suggest that no effort to eliminate the need for removal may in fact be considered a reasonable effort, we note that the statute clearly indicates that the juvenile's health and safety are the paramount concern in assessing reasonable efforts. As such, the court's determination that reasonable efforts were made, despite the lack of evidence of any effort to return Teresa to the home, is not unfounded, because in the present case, there is evidence that returning Teresa to the home would be dangerous to her health and well-being. And so I think, again, it's important to note that it's clearly indicated in statute that the juvenile's health and safety are the paramount concern overarching reasonable efforts. Yeah, John.
Isn't that really a backdoor to no reasonable efforts are required? I mean, if you can make a finding that there's no efforts and that's reasonable, that's basically saying that reasonable efforts are not required.
Yeah, I think you're right. I think it does tie back into that. Any other thoughts on that? I don't want to advance the notion that no reasonable efforts can be upheld as reasonable efforts, but I think the point is important about the health and safety is always the paramount and overarching concern. Vicki?
I thought that the no reasonable efforts required meant that they were never required. And also that it was basically, this family will not be unified because of those criteria, you know, having killed another child or torture or whatever. But I thought that sometimes reasonable efforts may not make sense right at the initial stage, but you wouldn't necessarily say they're not. I thought the no reasonable efforts required is like for the rest of the life of the case.
Yeah, that's right. I thought what John was saying was that maybe the court was essentially thinking there was, similar evidence, but not exactly taking that pathway, but sort of making a parallel analysis. Is that what you're saying?
For the federal audit, that matters. And this, but what they say is the language they want is that reasonable efforts would not have prevented the removal because of the reasonable efforts could not have prevented the removal because of the emergency or because of this or that. And they say that no reasonable efforts are required is trigger or fast track PCR. So I don't know if that's consistent or accurate, but that's what they say at the audits.
Right.
They do make a mistake.
Yeah. Okay, and then just kind of quickly for fun, I had a law clerk with some extra time this summer. And so I had him look at a sample of reasonable efforts cases that were addressed at termination of parental rights. And again, it's just a sample. You can see it's a small N for the researchers in the room. But looking at cases in which the Court of Appeals or Nebraska Supreme Court, either of our appellate courts, the reasons that the court cited when reasonable efforts had failed to correct the conditions leading to adjudication. And so there's overlap because oftentimes there were several reasons that were indicated, but you can see from the cases that we found that squarely addressed the issue, missed therapy, if you can see that's the tallest one, was the most common reason that the Court of Appeals noted. So if you're a parent's attorney, make sure you get your clients to therapy, and if you're a caseworker, to try to remove barriers to therapy. And then also the housing and employment financial is pretty big, and that's, I think, something that the caseworkers can try to provide resources to address. And then also parenting skills was the other one that's cited there. Okay, and I just have a list here, several slides of some best practices that could be used in reasonable efforts cases. And this is something that I'm borrowing and adapting from Judge Keyes, who gave a presentation at the Children's Summit last year. And he listed these as a potential basis for a no reasonable efforts finding. And so I've sort of flipped them around to think about things that could be best practices. These are to avoid removal, to fully investigate a case, to provide appropriate services for a sufficient period of time. I won't read all of them. To identify and explore potential relative and non-relative placements. And then some best practices to reunify, develop a case plan around the court's finding as the cause of separation, match services with needs, provide meaningful visitation, transportation, provide good information, follow up with service providers, obtain meaningful reports, involve parents and others in the case planning, communicate the contents of the case plan, particularly if there's a language barrier that should be provided to the parent in the language, their native language. communicate, period, identify and work with the family's strengths, meet the needs of the child, comply with interstate compact if that's applicable. You can read through these, and then I added the sibling placement as part of fostering connection. Okay, so now on to some ways to enforce reasonable efforts in court, and this is going to focus a lot on the attorneys in the room and what you can do, but also I want to try to involve what stakeholders can do if a reasonable efforts issue arises in court. And here's sort of a list of some ideas that I had about how reasonable efforts can be enforced in individual cases. Ask the court to make a specific order with regard to placement or other services. And I just want to mention with that, I think there is a strong line of Nebraska appellate cases regarding the juvenile court's authority to order specific services, for example, to order a specific therapist or to change a caseworker. I think there may be a limit to that. It's a very strong line of cases, but I think we do need to be careful not to have orders that are micromanaging the department, or it's possible we could run into some separation of powers concerns with that. But overall, as I said, the Nebraska appellate courts have a really strong line of cases regarding the court's authority. And I think specific orders are helpful. And then object to reasonable efforts findings if you don't think reasonable efforts has been made. And to do that at the detention hearing and subsequent hearings. Also, present an alternate case plan under 43-285, and that specifically provides that if any other party proves by preponderance of the evidence that the department's plan is not in the child's best interest, then the court shall disapprove of the case plan. And so I think in some cases it may be helpful to present an alternate plan. We shouldn't be accepting boilerplate case plans, and we shouldn't be writing boilerplate case plans. And so in some cases it may be appropriate, as I said, to present an alternate plan to the court. And then a reasonable efforts motion and contempt motion, I have separate slides on that. And then I understand that some attorneys have asked for a stay of the 15 out of 22 requirement, and I don't know exactly how that works or what the effect of that is, but the statute does provide that the state is required to file a petition to terminate parental rights at 15 out of 22, but that's not required if the parent hasn't had an opportunity to comply with services. And so that's another option. And if there are any others from the group, be interested to know. Okay. And then I just want to digress a little bit to talk about 4E, and you have that article that Judge Gendler mentioned from the Nebraska lawyer. But just, and really the background of that is that I felt like I didn't understand 4E very well. So did some research and then wrote up that article with what we had learned about 4E. But Title 4E is the primary federal source of dedicated federal funding for child welfare cases. And it generally provides federal assistance for the room and board, the foster care maintenance payment, adoption assistance subsidy, and then also some administrative and training costs for the department and a few other things. Eligibility for 4E has a couple of layers. The first one is income eligibility. And so stay with me here because it's kind of complicated. But federal 4E for foster care income eligibility remains tied to an outdated income eligibility for AFDC, which is a now defunct pre-welfare to work cash welfare program. It's now TANF. But 4E foster care funding eligibility is still linked to the income eligibility for AFDC back in 1996. So, and to give context, in Nebraska, in 1996, the AFDC income eligibility guideline for a family of 3 was about $675 a month. So if a child's removed from a home of 3 today that makes more than $673 a month, then they're not eligible for federal 4E. Second, there is a number of other requirements that are essentially placed on the agency and the court in order to meet 4E requirements. So for example, the foster home has to be the child has to be in a licensed placement, the contrary to the welfare findings that the court makes, and also the reasonable efforts requirements that the court makes are required for federal 4E funding. And so that you can see that a number of cases don't qualify, either because of the income eligibility guideline, which is a big issue at the federal level. The Fostering Connections Act just delinked that income eligibility for adoption assistance, but it still remains for foster care. So that's a big policy issue that we're working on, and lots of advocates across the country at the federal level. And also, Nebraska has a pretty low penetration rate. So the percentage of kids who are eligible for federal 4A in Nebraska is one of the lowest in the country. It hovers around, I think, 30%. I haven't seen the more recent numbers. So you can see that when you're seeking a no reasonable efforts finding, that can have an impact. If a case is still eligible for federal 4E, that's a pretty big stick because there's an interest in keeping that case eligible for 4E. If the case isn't eligible for 4E, it's still important, as Vicki was saying, in terms of the federal reviews and just in terms of making your record to try to raise that issue. And I think in a particular case, an attorney might not know whether a case is 4E eligible or not, and I'm not sure whether the caseworker would know necessarily. But that's sort of the background to a no reasonable efforts finding. When a no reasonable efforts finding is made, what happens is that the state loses the federal match for that case, which is a percentage of the cost. And so I want to just make the point that I think some people are concerned if I seek a no reasonable efforts findings and that's made, am I shooting myself in the foot because then does my kid or my family lose that funding? The state is then still, or the lead agency now, is still required to provide that service. It's just that the state or the lead agency has to pay 100% of the cost. We're not receiving the federal match for that case. Oh, question. Yeah.
Okay. Is there an income limit for the 4E funds? In other words, if the parent or the household earns so much, are they disqualified from 4E funds in any event?
Yes.
And what are the limits in Nebraska?
It's still tied to that AFDC income eligibility guideline,
Which is how much?
which is, as I gave the example, for a family of 3 in 1996, it's about $670 a month. So you have to be pretty low income.
Okay. And that's not uniform state to state, is it?
I don't believe so.
So,
Yeah. So that may tie into our low penetration rate, for example. Yeah, John.
I was just going to point out that even if you don't have the 4E funding for the foster care subsidy, the kids may still qualify for the adoption subsidy, even if the reasonable efforts get messed up, the wrong findings or whatever. Because the Fostering Connections, I think, delink the adoption subsidy from the reasonable efforts finding.
That's right. Fostering Connections delink, so there's no longer an income eligibility threshold for adoption assistance. And so, as I was saying, this is kind of a big policy issue at the federal level, and that gave a lot of advocates hope that that was a first step, and the second step will be to delink for the federal 4E foster care. Is there another question? Okay, great. So I just want to mention a little bit about bringing a reasonable efforts motion. This is a motion that seeks to have the juvenile court make a no reasonable efforts finding. And I've seen several different motions and what they look like, but generally it moves the court for an order making a reasonable efforts findings. It should set forth facts about the specific ordered services that weren't arranged or paid for, or specific reasonable efforts, actions that weren't taken. It may be necessary to allege communications that were made with a caseworker and where the issue broke down or where the error of reasonable efforts occurred. Procedurally, as I said, remember Dwayne G., it may be set as a review hearing. There's no right to a separate hearing, reasonable efforts hearing, after the Dwayne G. case. And be prepared to put on evidence of the reasonable efforts failure, what should have been done, and the effect or the risk of the services not being provided, I think is helpful. And then in terms of non-attorney stakeholders and how you can be helpful in this process, I think CFS specialists and service coordinators are really at the heart of this. If possible, work together to get services in place to explain your rationale, explain what barriers exist, and to try to work together with the team in terms of how those barriers can be addressed. Because I think and hope that sometimes bringing these reasonable efforts motions can be helpful in terms of getting the parties back to negotiating on these issues and trying to find solutions. And then for other stakeholders like foster care review board or foster parents, other service providers, if you think that certain services or reasonable efforts haven't been provided, I would encourage you to speak with a caseworker or an attorney and raise your concerns, because you may be able to be helpful in the process. And then another option for attorneys wishing to, that when court orders aren't followed, is to file a contempt motion. And this is typically done by filing an application for an order to show cause, which moves the court for an order requiring HHS or the lead agency to appear and show cause why it should not be held in contempt for failure to follow a court's order. And so reasonable efforts, I think, motion could be brought when reasonable efforts haven't been provided. Maybe it's not clear in the court order, but this needs to be where there's a court order that has clearly not been followed, and also there's a requirement under the statute to make a showing that disobedience with the court order is willful.
Sarah,
Yeah.
what about the issue of qualified and sovereign immunity on behalf of the state? How do you deal with that? Do you have any case law that says?
I don't. That's a good question. What's that? That's a good question. I don't know if that's ever, we work with attorneys for our Legal Resource Center, and I understand that these are, brought with some regularity, and I don't know that issue has been raised. So that's a good question. Does anyone else?
Well,
Yeah.
who do you direct this action against when it's a lack of funding and not enough people?
Yeah, that's.
So who's the target? Who should you be complaining about?
You mean under the child welfare reform? Who's the party to allege the willful? I think that you have to, I have a slide on this about the privatization. I think you have to allege that both parties have been, not complied with the order. And, in terms of whether there's no money, I think that's a question in terms of what's the state's obligation to step back in if something's been court ordered and the service hasn't been provided and the agency's, either unable to do that or not willing to do that.
So if the funds aren't there, is it you direct the action against the agency or against a different entity? What do you suggest?
I think both. Because the way that my understanding of the way that the contracts work is that the state is legally obligated, ultimately, when children are taken into custody, that's the responsibility of the state. But under the contracts, the lead agencies are financially responsible. But, we'll see if we get to a point where there's just no more money, and what happens at that point. And I think that's an open question. That's the question. That's the question.
It has occurred in other jurisdictions, has it not? When the whole system is broken. So is there a receivership?
I haven't seen any case law on that, or.
Well, I think the District of Columbia system was put into receivership about 10 years ago,
Mm-hmm.
maybe longer than that.
Mm-hmm.
Because of its inability to deliver services.
Right.
They didn't have a federal action, as I understand.
I wish that I could predict what will happen. I hope that, we make it through this bumpy road, but I think this is where these issues start to come up. And I know that you're all seeing lots of cases where kids aren't getting services and there aren't money, and that's what you're hearing. And I know it's hard to say, keep pushing, because the money might not be there. But children have right to receive services, and families have rights also to family integrity. And so, I think those issues are gonna have to be litigated ultimately if a policy solution isn't found. And that's why I think there's a good question. The state's ultimately legally responsible. And so, I think you in these motions would have to address both the lead agency and the state's obligation and see where that comes out. Sorry, I can't be. Don't have a crystal ball. Okay, and I see I just have 5 more minutes, so I'm gonna just wrap up. Sort of have a list of what different players in the system can do. I think I've mentioned that. The common denominator is just to raise issues, no matter who you are, and to try to work together to the extent that you can when you're seeing that services aren't available or being made according to the case plan. And there's the slide. My reading of it again is that the state's legally responsible, lead agencies are financially responsible, but ultimately, I think there's some question there in terms of the interplay. And then I know there's some confusion about the role of the CFS specialist and the service coordinator, and that there's been some attempt to clarify those roles. At the end of the day, my understanding is that it's the job of the CFS specialist to sort of oversee and make the major decisions, and the service coordinators to do the arranging of services. But that's, I think, sort of an ongoing issue as well. And then I just threw out some issues I think may be bubbling up in terms of reasonable efforts. This might end up getting litigated or hopefully can be addressed in individual cases in terms of payment of services versus arrangement of services. Is it reasonable to simply arrange for services if a family's going to be on a wait list? Is that reasonable? I would argue no. What happens when services aren't available in the service area or in the region? I know that's an issue out here in central Nebraska. And so those are some ongoing concerns about reasonable efforts and that may come up in your cases, and would urge you to argue and to work on. And then some ways to address reasonable efforts issues out of court. In appropriate cases, work together with HHS and the lead agency to get services in place early on in a case. I know a lot of good work is happening with the pre-hearing conferences and the team meetings. And then my personal favorite is to just do your best to identify family and community supports, because that can really make a difference in cases. And then old-fashioned social work, I'll probably just end on this. This is a term that I borrowed from Jessica Vanderkoy, who is the director of the Right Term program. And I think it just denotes the idea that sometimes the most important thing that we can do in cases is just to really pound the pavement and pick up the phone and do what you guys are doing every day to find those services and to make those calls and to think outside the box. Sometimes we become so fractured that what is really needed sometimes is to go back to old-fashioned social work and to work with families to find the services they need that might not always be what is standard in other cases. That's the last. I don't know if we have, I think we're out of time. 2 minutes? So I know I've raised a lot of things really quickly. Here's some other questions in terms of whether reasonable efforts issues are being raised in your jurisdiction, and how are they handled, and what other service barriers you may be seeing. I think I will just, if there are any questions, be happy to take those. Otherwise, my contact information is here on the last slide. And if you have issues of reasonable efforts that are arising in cases, we do some sort of technical support for attorneys when issues arise in cases, and I'd love to have more time to look into some issues or talk to you about what you're seeing in your individual cases. John?
If there's no specific statute that gives like a parent's attorney the right to file a motion for reasonable efforts, is it basically just a request for specific findings and conclusions at one of the specified hearings that you could file? Just say, Judge, I think there's a problem with reasonable efforts. I want you to make a specific written order on findings of reasonable efforts in your conclusion of whether they're being made. Does it really have to be that much? I mean, that would be the simplest way procedurally, I think.
Yeah, and I think, the Dwayne G case, the way I read that is saying that a parent or another party doesn't have a right to a separate hearing on the issue of reasonable efforts. I know those happen. I've heard that those happen sometimes. But again, procedurally, I think you're right. It's just asking for an opportunity to, address the issue of reasonable efforts, and that oftentimes that's done in the context of a review hearing. Is that how it's done in your experience in this jurisdiction?
I don't think we've had it. most of my work is in Hall County. I don't think we've had a lot of specific arguments over reasonable efforts that I've worked on. It's usually brought about, those issues usually come up by objecting to a proposed case plan
Right.
or amended case plan, or asking that something be added to that.
Right. Yeah. Go ahead. Yeah.
But don't, in order to appeal that reasonable, the finding on that reasonable efforts motion, you have to have evidence on the record that reasonable efforts were made, right? So,
Right.
you're gonna probably need, file the motion, have some discovery, actually get, I don't know, 4 hours or more on the court's calendar, so you can have a real hearing. Suggestions on how you do that?
I would think that that's one of the reasons why you would do a reasonable efforts motion rather than, separately, rather than to just object to a reasonable efforts finding. And so you have an opportunity to really put on evidence and raise the issue of reasonable efforts separately.
You can appeal a finding on a reasonable efforts motion, right? You can appeal a finding on reasonable efforts.
It's a good question, whether that's been a final order or not. I don't want to answer that, but I will go back and look on that. I don't want to say one way or the other whether that in itself is a final order. I'm not sure if there's case law on that, but I think we're out of time. But my contact information again is on the last slide, and I'd be happy to answer any questions after the presentation.